What happens when a beloved pet dies 2 years before its owner and an $80,000 pet trust vanishes into legal limbo because of one missing clause? In 2023, the Massachusetts Supreme Judicial Court had to answer this exact question in the Jablonski case. Here's the problem. If Licorice the Cocker Spaniel predeceased her owner, the testamentary trust would lapse under Massachusetts law. And the will's residuary clause created a circular reference, pouring failed gifts back into the invalidated trust. But buried in Article 5 of that pet trust was a charitable remainder provision. With language so ambiguous about whether it required the pet's survival, it would take Massachusetts' highest court to determine whether $80,000 goes to charity or to probate for 4 fighting heirs, nieces and nephews. In episode 108, Pet Trust Gone Wrong, Trouble Transferring $25 million, we examine how 3 separate pet trusts expose critical estate planning failures affecting pets and people, explore legal battles from Massachusetts, Manhattan, and Milan, Italy, featuring a $12 million Maltese and a $13 million stray cat, and analyze the court decisions detailing what went wrong that wealth managers, financial advisors, estate planners, and pet owners should avoid before preparing pet trusts. Join us to see how it litigated.
When fortunes collide with courtrooms, wealth managers, financial advisors, accountants, fiduciaries, and lawyers need real answers. Welcome to Wealth Litigated, where Professor Kelly Lease Murray, J.D., lawyer, legal scholar, and retired Vanderbilt Law faculty, analyzes actual courtroom wins and losses in asset protection to deliver actionable insights that optimize your client's wealth outcomes. From explosive family feuds over fortunes to sophisticated financial fraud, each week we explore what worked to protect wealth and what exactly went wrong, so you get it right. And now, here's your host, Professor Kelly Lease Murray.
I'm Kelly Lease Murray, and this is Wealth Litigated, delivering all the drama of true crime without the blood. We break down actual court cases that impact your professional practice and your client's wealth outcomes. Let's gavel in. Pet trusts have exploded in popularity, and they're not just for billionaires. But in this deep dive, analyzing pet trust case law from Massachusetts and Milan, Italy, we expose the dangerous gaps that can turn the most well-intentioned pet trust planning into an estate administration nightmare. These actually litigated cases confirm critical pet trust planning criteria about validity, enforceability, funding, and trust administration. And we're going to look at what can go sideways when the unanticipated happens. In our primary case, a 2023 decision from the Massachusetts Supreme Judicial Court, that's the highest court in the state of Massachusetts, one missing clause sent an $80,000 pet trust into years of litigation. No examination of pet trust would be complete without including Leona Helmsley's 2007 $12 million pet trust for her Maltese named Trouble. We're going to reserve that for part 2 and focus instead on the first 2 cases. We can start with the Massachusetts case from 2023. That's the estate of Jablonski with a Cocker Spaniel named Licorice, and also an Italian case of a stray cat named Tommaso. In the Italian trust case concerning the stray cat named Tommaso, the cat was supposed to inherit $13 million. The problem? Italian law doesn't permit animals to inherit directly. But because there were no people subject to inherit, either under the estate planning or through intestacy, the court was able to resolve in a mediated fashion what to do with the cat and the bequest. These are the players. The grantor was 94 years old when she passed away. She died in 2011, and her entire estate of $13 million was directed to go to Tommaso, a 4-year-old stray cat. Without direct heirs, there were no people to challenge the pet trust. That's a huge distinction, and we'll see how that comes into play with other pet trust litigation. There was a caretaker whose identity needed to be kept confidential to avoid security threats to the cat. The legal framework, given Italian law, required a creative solution that would not have been available with possible heirs objecting. Here's what worked And here's what was left unresolved with the solution for Tommaso, the 4-year-old stray cat. Without family conflict, without court challenges, a confidential caretaker was appointed, and the confidential caretaker is the person who manages the money on behalf of the cat. That's how they circumvented the Italian legal prohibition against pets inheriting money. But what was left unresolved is a warning for other pet trust planning. For example, there was no charitable remainder clause. That's a huge mistake. Disposition of leftover funds remained unclear. There's no accountability mechanism regarding this caretaker. And what happens when the 4-year-old stray cat dies? None of that was addressed either in the estate planning nor in the court-mediated solution, which brings us to an excellent anonymous quote. "I work hard so my dog can have nice things." This quote was included in a detailed pet trust planning article by Laura Martin, published in 2024. I've included 2 of the main sources for episode 108 and part 2, which is episode 109, specifically Professor Jerry Beyer from the Texas Tech University School of Law and Laura Martin, who published 2 companion pieces in 2024, Give a Dog a Bone, a Lifetime Security, Factors to Consider in Pet Trust Funding, and separately, Pet Trust Taxation. Both have excellent resources, PDFs, downloads. You should take a look at what they have available because there's a lot to take in when beginning pet trust planning. Laura Martin cited the Leona Helmsley Troubled Pet Trust, but she also mentioned 3 other celebrity pet trusts. Oprah Winfrey apparently has set aside $30 million for her dogs. Betty White set aside $5 million for a golden retriever named Pontiac. And then Gail Posner Trust, benefiting 3 Chihuahuas, included her $8 million mansion and a $3 million pet trust. Pet trusts are not just for billionaires, and these statistics were included in the Laura Martin article. Total pet trust spending and pet spending in general in 2022, over $136 billion. The projected pet spending through 2030 is $200 billion. Between 2018 and 2022, 52% increase in pet spending. 52% of pet owners spend more on their pets than they spend on themselves, and 2/3 of pet owners consider the pets in long-term financial planning. That's why we're devoting 2 episodes to pet trusts and what can go wrong so you get it right. Among the key insights for effective pet trust planning, we're going to focus at the top on the termination trap. This is that Massachusetts 2023 pet trust. Additional issues that we'll cover throughout episode 108 and 109 are contingency planning, funding determination, undue influence red flags, acceleration of remainders, and practical funding formula. Jablonski from 2023 is one of the more recently decided pet trust litigation cases where one missing clause sent the $80,000 pet trust into years of litigation. And let's just look at that number. This is not a billionaire, but this was a beloved pet that a senior who had her estate planned wanted to take care of. And some facts that she and her estate planners didn't account for derailed everything. Ms. Jablonski was 83 years old when she passed away in May of 2019. Her dog, named Licorice, was a 15-year-old Cocker Spaniel. And here's the material fact. The dog died 2 years before the grantor. That messed up everything that was planned, and I'll explain. There were no direct heirs, no surviving spouse, no children, no parents or siblings. Her closest heirs were 4 nieces and nephews, apparently 2 nieces and 2 nephews. One niece held durable power of attorney while Ms. Jablonski was in the nursing home. The others were the ones who challenged the $80,000 pet trust because they were the intestate heirs. Now, how was this trust built? It was governed under Massachusetts law, and Massachusetts has a statute. The funding did not happen until the grantor's death. The primary purpose was the care of the beloved Cocker Spaniel named Licorice. Charitable remainders were not specified. That's another material fact. And then the bequest structure. Here's where it went sideways. Article 5 required the pet to survive the grantor. Well, our facts are the opposite. The pet died 2 years before the grantor. So Article 5, the pet trust failed given those facts. And then Article 4, which is the residuary clause, it was written circularly. The circularity generated from the pet predeceasing the grantor sent everything back into a trust that never happened because the pet predeceased the grantor. Here's a visual timeline of what went wrong. The will was drafted in 2013. In March of 2017, Licorice, the Cocker Spaniel, passed away. 2 years later, the grantor passed away. Apparently, she was unaware of what had happened to Licorice. She may have had diminished capacity because there's no change to her estate planning. And starting in 2019, after her death, through 2023, the legal battle began with her nieces and nephews. Not all of them. One of them had power of attorney over her, but the others in combination challenged the trust because the pet died before the grantor. And they're not wrong. Legally, the pet trust failed, which in their argument sent the $80,000 through intestacy and not through the charitable remainder. The charitable remainder wasn't specified. That's another problem of the structure here. And because the charitable remainder was not specified by the grantor, it was supposed to be determined by the trustee. Without a trust ever forming, we have another ambiguity that went all the way up to the Massachusetts Supreme Judicial Court to decide. That decision came down in August of 2023. The Massachusetts Supreme Judicial Court held the following: the trust terminated before it became operable. This was a testamentary trust for a pet. It required the grantor to predecease her pet in order to become functional. Because the pet died before she did, the trust never happened. The charitable remainder was also ineffective because the interest never took effect and no funds were ever under the trustee's control, so the trustee could never choose a charitable remainder. The acceleration required clear intent, so acceleration of remainder necessitated clear and unambiguous intent. The Massachusetts Supreme Judicial Court held the intent was ambiguous. And the key, the circular residuary clause, because the pet trust failed factually. That was Article 5. In Article 4, the residuary clause, it looked like it would work if the facts had played out, but the facts didn't play out. So this residuary clause was pouring funds back into a trust that never happened because the pet predeceased the owner. Fatal flaws of the planning: it was failure to plan for the unanticipated sequence of deaths. A testamentary pet trust requires the grantor to die first. It doesn't fund until the owner's death. Here, the pet died first. Pet predeceasing contingency was missing in Jablonski. There were no named charities, another gap. The circular residuary clause, because Article 5 failed with Licorice, the Cocker Spaniel, predeceasing the grantor, and then the resulting intestacy. The result in 2023 was to remand back down to the trial court to determine at a trial what these ambiguous provisions actually meant. The total trust is $80,000. They've already been litigating for years. What is going to be left to be divided among the four? A lot less because of the lack of specificity and the gaps, the unanticipated factual changes, for example, in the order of deaths between the grantor and the pet. Which brings us to what testamentary trusts can't do. This is a critical blind spot in many pet trusts and general estate planning, including the disability gap, because with senior clients, disability and the inability to take care of your pet is a more urgent issue than predeceasing the pet. Testamentary trust is a less expensive option, which is why it's common, but there is no protection for the pet during the owner's incapacity. It's exactly the facts of Jablonski. It's will created. It's only activated at the owner's death. With the Jablonski facts, with the pet predeceasing the owner, grantor, the pet trust never took effect. By contrast, an inter vivos trust simply means during your lifetime, is created and funded during the owner's lifetime. It takes effect immediately upon signing and funding. And we're going to also look at funding options and funding challenges. It protects the pet during the owner's incapacity, and it survives if the pet dies before the owner. And the owner can amend this inter vivos pet trust during the owner's lifetime, but there are higher upfront costs to create it. The issue for your senior clients considering a pet trust should include incapacity, the potential for incapacity or reduced capacity. Is your client's pet protected? A failed testamentary trust obviously did not work under the Jablonski facts because the pet died before the owner. Lifetime protection is only available through two options, the inter vivos trust or a pet power of attorney. And then senior client incapacity is a more immediate risk than death of the grantor. Now, these two solutions, pet power of attorney coupled with a testamentary pet trust or an inter vivos pet trust, those have been included in depth on a website by Professor Jerry Beyer. Have a look at his resources. Pet power of attorney includes a supplemental incapacity document. An agent is authorized to care for and make decisions about the pet, and it works alongside a testamentary trust as a gap filler. This pet power of attorney was missing in the Jablonski case and would have changed the outcome there. The inter vivos pet trust is more expensive to start with. It's funded during the grantor's lifetime. It activates immediately upon signing and funding, and it provides continuous pet protection throughout the owner's life. But what happens when money runs out before the pet dies? The consequences of underfunding and the one critical clause you should consider including, that's in our next section. There's a hidden termination trap. When funding of the pet trust expires, in many states, that will cancel the trust automatically. Some states permit trust cancellation if the value of the pet trust goes below $100,000. There are no published cases on how courts will apply this termination provision, and the pet's welfare is at risk. An underfunded trust can terminate, leaving the pet without guaranteed care. The guaranteed protection, the only way to ensure that is to maintain the trust value above this $100,000 threshold throughout the pet's life. And that's a threshold in many states. Make sure you check your state. According to attorney Laura Martin, underfunding is a far greater risk of pet trusts than overfunding. She includes important statistics like the annual cost of care as a starting point. What is the annual cost of care for a dog, a cat, a horse, or a large parrot? They also have different life expectancies, which would extend or reduce the total cost of care. For a dog, the annual cost is anywhere between $1,200 to almost $3,000, with a lifetime cost range of $20,000 up to $55,000, unless you're Leona Helmsley's dog, and we'll get to that in part 2. Cats, anywhere from just under $1,000 to almost $2,500 a year, and a lifetime range of $15,000 to $45,000 because of the longevity, the life expectancy of cats. Horses are extremely expensive, annual costs ranging from $8,600 to $26,000, and lifetime costs range $215,000 to $1 million or more for one horse. A large parrot with a lengthy life expectancy has an annual cost range of $1,000 to $2,700 and a lifetime cost range of $35,000 to nearly $300,000. Life expectancy planning beyond the average. A medium dog, 8 to 14 years. The planning lifespan should be about 17 years. A house cat, 12 to 18 years. The planning lifespan over 22 years. A horse, 25 to 30 years with a planning lifespan of nearly 38 years. And a large parrot, typical lifespan 50 to 65 years with the planning lifespan of 81 years. And just a quick sidebar, I can tell you horses do live a long time because my mother's childhood horse was alive when I was in grammar school. I actually rode my mother's horse with my mother, which was a pretty cool experience. So horses are long-lived, and apparently large parrots are even longer-lived. The petflation problem is real. Look at this data. Historical average of U.S. inflation between 1989 and 2019 is 2.5% annually. Petflation since 2019, nearly 22%. Petflation. What would that do to your pet funding planning for a pet trust? Costs that are often Costs that are often overlooked in funding calculations, non-annual animal expenses, and trust administration costs. Among the non-annual animal expenses, property maintenance, vehicle trailer purchase, caretaker home modifications, end-of-life care in the remains disposition, emergency veterinary care, and above-average inflation buffer. In the trust administration cost side, fiduciary compensation, attorney and accountant fees, insurance premiums, income taxes, litigation enforcement reserve, and interfiduciary dispute costs. We've already seen some of that. Attorney Laura Martin, in her 2024 articles, includes a detailed 9-step funding framework that I'm showing here, but you should read her articles directly. This structured approach helps calculate adequate pet trust funding. First, calculate the annual care costs. Next, determine life expectancy. After that, project total care costs, account for inflation, and consolidate the pet costs. Budget for non-annual expenses, estimate administration costs, reserve for extraordinary costs, and then add that buffer. She recommends a reverse analysis working backwards, starting with the client contribution, work backwards to determine the scope of the trust, because the potential outcome encourages clients to reassess the funding amount or the trust structure, because a direct bequest is far less expensive and may cover the care, the room and board, so to speak, of a pet more directly than a pet trust that fails. And then we have extraordinary animal-caused injuries like dog bites. There are 4.5 million dog bites annually. The average dog bite settlement is $65,000. Total dog bite claims in 2022 were over $1 billion, and the average civil litigation cost for dog bites is $77,000. Funding. The pet trust, in order to exist, needs to be funded, and it doesn't just have to be cash. We're looking at how to fund a pet trust when liquid assets are limited. This is included by Professor Jerry Beyer on his website. Take a look there. He suggests 5 ways to fund a pet trust. These sound familiar to how you fund people trusts: direct transfer, life insurance, pay on death accounts, retirement plan designations, and pour over will provisions. To summarize, underfunded: what happens when the pet trusts run dry? If trust funds are exhausted, the trustee cannot legally pay for the pet's care. Without a plan, the pet has no guaranteed home and no guaranteed care. This frequently happens. Here's the clause you need: a fallback clause that names a specific person or an organization to receive the pet when the pet trust funding is exhausted. This should be agreed to before you sign the pet trust. They should be agreeing to take this pet. Options include a no-kill shelter, a breed-specific rescue, or a professional animal care organization. And then there's pet trust tax considerations. That is beyond the scope of this episode, but I do want to share with you some of attorney Laura Martin's categories to keep in mind. She has a separate article published in 2024. Have a look at that. Estate tax, income tax, gift tax, and charitable deductions. Even with the current federal estate tax exemptions, depending on what state your client's trust is administered in, estate tax at the state level could be significant and bring back those issues. So estate taxes at the state level, New York, California, but Massachusetts and Oregon, because their exemption is much lower, as low as $1 million. The rest would be taxed. That would affect ultra high net worth clients. Income tax issues. Pet trusts are taxed separately with compressed brackets. The gift tax. Funding a pet trust during the owner's lifetime can be a taxable gift. And then, of course, the charitable deduction aspect. Wrapping up, the key reminders: the Jablonski warning. One missing clause can lead to intestacy. The pet trust can fail, and intestacy heirs, potential heirs who would inherit if the pet trust fails, can challenge it, which would further drain funds from the estate. Underfunded warning. Underfunding is more of a risk and a more serious risk than overfunding. And the preview of episode 109, where we're going to take a look at the Leona Helmsley $12 million trust for her dog Trouble. which was overfunded and which a court did drastically reduce by 83%. The difference there is documentation, the evidence of the costs allocated, justify the funding amounts. Courts can reduce excess, but they do approve significant care costs when they are documented. In the show notes, be sure to look for additional resources for further reading. Thank you for joining us. Stay tuned for a preview of our next episode. How does a $12 million pet trust get gutted in court, while a $4.7 million pet trust survives a court challenge without losing a dime? Same state, same statute, even the same year. The only difference was in the drafting. Here's the multi-million-dollar problem. Leona Helmsley left $12 million for Trouble, her Maltese, and a New York court reduced it to $2 million because the funding couldn't be justified against documented care costs. But when an executor tried the same argument the same year to reduce Lenore Abel's $4.7 million pet trust for two cats named Polka Dot and Ginny, the New York court refused, ruling that granting the petition would improperly rewrite the decedent's express intent. The difference? One drafting decision that exposed a tension no court has fully resolved. How much is too much for a pet trust, and what evidence decides? In episode 109, Pet Trust Gone Wrong, part 2 of 2, we compare how evidence, documentation, and specificity determined opposite financial outcomes under the same statute, expose the structural conflict of interest that many pet trust documents ignore, and reveal the critical monitoring and identification provisions every pet trust needs. Join us to see how it litigated.
This is Wealth Litigated, where the real courtroom battles we analyze today are your roadmap to stronger asset protection and better wealth outcomes. Follow us on your favorite podcast platform or subscribe on YouTube so you never miss a weekly episode. Questions or cases? Visit wealthlitigated.com/questions. This show is for informational and educational purposes only and does not constitute legal, tax, or financial advice. No attorney-client relationship is formed. Consult a qualified professional for advice specific to your situation and jurisdiction. Wealth Litigated is now adjourned.